Case 16, American Airlines v. Wolens. We find ourselves for this case in the Supreme Court of the United States. Here are the facts. In consolidated state court class actions brought in Illinois, plaintiffs, respondents here, as participants in American Airlines frequent flyer program, challenged Americans' retroactive changes in program terms and conditions, particularly Americans' imposition of capacity controls, which are limits on seats available to passengers obtaining tickets with frequent flyer credits, and blackout dates, restrictions on dates such credits could be used. Plaintiffs alleged that application of these changes to mileage credits they had previously accumulated violated the Illinois Consumer Fraud and Deception Business Practices Act. From here on out, we'll call that CFA. And constituted a breach of contract. American answered that the Airline Deregulation Act of 1978 preempted plaintiffs' claims. The ADA prohibits states from enacting or enforcing any law or other provision having the force and effect of law relating to air carrier rates, routes, or services. While the Illinois class action litigation was sub judice, this court decided Morales. Morales defined Section 1305 relating to language to mean having a connection with or reference to airline rates, routes, or services, and held that NAG guidelines on airline fare advertising were preempted under that definition. The Illinois Supreme Court, post-Morales, ruled that plaintiffs' monetary claims survived for state court adjudication. Those claims related only tangentially or tenuously to rates, routes, or services, the Illinois court reasoned, because frequent flyer programs are peripheral, not essential to an airline's operation. So what is the issue? Whether the ADA preempted plaintiffs' claims. The court held that the ADA's preemption prescription bars state-imposed regulation of air carriers, but allows room for court enforcement of contract terms set by the parties themselves. The court affirmed in part, reversed in part, and remanded. Let's look at the reasoning. Morales does not countenance the Illinois Supreme Court's separation of essential operations from unessential programs. Plaintiffs' complaints, accordingly, state claims relating to air carrier rates, that is, Americans' charges in the form of mileage credits for tickets and class of service upgrades, and services, that is, access to flights and upgrades unlimited by retrospectively applied capacity controls and blackout dates. The full text of the ADA's preemption clause and the congressional purpose to leave largely to the airlines themselves, and not at all to states, the selection and design of marketing mechanisms appropriate to the furnishing of air transportation services impel the conclusion that Section 1305 preempts plaintiffs' CFA claims. The Illinois Act is prescriptive, controlling the primary conduct of those falling within its governance. The Act, indeed, is paradigmatic of the state consumer protection laws that underpin the NAG guidelines. Those guidelines highlight the potential for intrusive regulation of airline business practices inherent in state consumer protection legislation. The guidelines illustrate that the Illinois Act does not simply give effect to bargains offered by the airlines and accepted by customers, but serves to guide and police airline marketing practices. The ADA, however, does not bar court adjudication of routine breach of contract claims. The preemption clause leaves room for suits alleging no violation of state-imposed obligations, but seeking recovery solely for the airline's breach of its own self-imposed undertakings. As persuasively argued by the United States, terms and conditions airlines offer and passengers accept are privately ordered obligations and thus do not fit within the compass of state enactments and directives targeted by Section 1305. A remedy confined to a contract's terms simply holds parties to their agreements in this instance, to business judgments an airline made public about its rates and services. Court enforcement of private agreements advances the market efficiency that the ADA was designed to promote, and comports with provisions of the Federal Aviation Act of 1958 and related DOT regulations that presuppose the vitality of contracts governing air carrier transportation. Such enforcement is responsive to the reality that the DOT lacks the apparatus and resources required to superintend a contract dispute resolution regime. Court adjudication of routine breach of contract claims, furthermore, accords due recognition to Congress's retention of the FAA's saving clause, which preserves the remedies now existing at common law or by statute. Nor can it be maintained that plaintiffs' breach of contract claims are identical to and therefore should be preempted to the same extent as the CFA claims. The basis for a contract action is the parties' agreement. To succeed under the State Act, one need not show an agreement, but must show an unfair or deceptive practice. Americans' argument that plaintiffs' claims must fail because they depend on state policies independent of the parties' intent assumes the answer to the very contract construction issue on which the plaintiffs' claims turn. Did American, by contract, reserve the right to change the value of already accumulated mileage credits, or only to change the rules for credits earned from and after the date of the change? That pivotal question of contract interpretation has not yet had a full airing and remains open for adjudication on remand. The plaintiff's claims for violation of the CFA are preempted by Section 1305 of the ADA, but plaintiff's claims for breach of contract are not preempted by the Act. This cause is remanded to the Circuit Court of Cook County for further proceedings on plaintiff's breach of contract claims not inconsistent with the opinion of the United States Supreme Court. In other words, he won a right, the right to sue. Ultimately, the case settled. A Cook County judge approved a final settlement valued at more than $100 million for members of the American Airlines Advantage Frequent Flyer program. Under the approved settlement, American would distribute up to 35,000 miles each to 4 million people who were members of this program when American changed its rules.